The first thing that you need to know before starting the divorce process is how you are married. So in South Africa, there are 3 marital regimes that you can enter into. The first, which is the default position, is in community of property. So by default, I mean is if you do not enter into an antenuptial contract, you are automatically married in community of property. Now, please bear in mind, there are also other types of marriages, such as religious marriages and customary marriages, which have similar principles now, but I'm not going to deal with those. I'm going to deal with the 3 primary marital regimes that currently exist in South Africa. There are some changes coming around, so we have to always keep in mind that the law is always changing. But the 3 are in community of property, and then out of community of property, including the accrual or excluding the accrual. For the latter 2, you would have entered into what's called an antenuptial contract or an ANC. If you didn't enter into an ANC, then you're married in community of property. So let me start by explaining what in community of property means. In community of property means that you and your spouse have what's called a joint estate. You don't have separate estates. It's not his estate and your estate, it's one estate. So everything that you buy, everything that you sell comes into or goes out of that one pot, essentially. So it doesn't matter if your spouse had a property before the marriage and that was registered in just their name, it still falls into the joint estate. So when you get divorced, the whole idea is you're taking that joint estate or that one big pot and you have to split it in half. Half is yours, half belongs to your spouse. So what's important to know if you're going to get divorced? It's very important to know what is in that pot. So, for example, if you have each purchased motor vehicles and the motor vehicles are under hire purchase, or in other words, a loan from the bank, those loans are not in your personal names. Even if they're registered in your personal name, they still fall into the joint pot. So you have to know what your assets are, both yours and your spouse, because remember, they're going into the joint pot. And you have to know what your liabilities are. Now, there are a whole lot of other consequences that come with married in community of property. For example, neither you nor your spouse can enter into any loan agreement where you're borrowing money, or for that matter, lending money to somebody else, or purchasing or selling anything of value, such as motor vehicles or expensive furniture and jewelry, or an immovable property such as a house, without the written consent of the other spouse. So you will know that if you're married in community of property, if you decided to buy a house together, you both have to go and sign the transfer papers, you both have to sign the sale agreement, all those sorts of things. So you need to be aware, if you're married in community of property, that there's one joint estate. Now, if you're married by way of an antenuptial contract, you and your spouse would have signed a written ANC. And that document is then attested by a person who's also an attorney, but they're called a notary public. And a notary has to sign that document. You have to sign it in their presence. And then the notary takes that to the deeds office and registers the ANC at the deeds office. So it's a registered legal document. Much like a deed for a transfer of a house, it's registered and it stays at the deeds office. Now, if you're going to get divorced, you'll need to have a copy of that, because that will set out whether you are married with or without the accrual system. If you're married without the accrual system, it means that whatever was yours remains yours. Whatever you've bought during the marriage is yours. The same applies to your spouse. If you've incurred debt, it's your debt. It's not your spouse's debt. It's not in a joint pot. It's yours. Out and out, which is excluding the accrual system, basically means that you each would walk away from the divorce with what is yours. Now, that was challenged, I think it's about 2 years ago now, where a couple who were married out of community of property and excluding the accrual approached the court to say that Section 7.3 of the Divorce Act is unconstitutional because Section 7.3 applied only to to marriages that were excluding the accrual that were entered into prior to the 1st of November 1984. And the court did declare this unconstitutional, which means now that people who were married after 1984, where they entered into an antenuptial contract and they excluded the accrual, can now apply Section 7.3 of the Divorce Act, which essentially means that the courts, taking into consideration various factors, can redistribute the assets of one spouse to another spouse if one spouse's estate has grown exponentially and the other spouse's estate has not grown at all, or to a smaller degree. The purpose of Section 7.3 was to ensure equity. In other words, because back in 1984 and still to this day, very often one spouse stays at home and looks after children or has a lot of households responsibilities, if you would, for example, looking after children, taking children to sport and so on, and is unable to further their career to the extent that the other spouse is able to, because they don't have necessarily the same responsibilities. And you then get a situation where the one spouse has a much greater estate than the other, and very often this happened to women, whereas men were able to increase their estate. Women were more often than not a stay-at-home parent and cared for children, and so they were not able to generate the type of estate that their husband was able to do. So that is why now, if you are married out of community of property and excluding the accrual, you must be aware that either you or your spouse can bring an application or can include in the divorce proceedings a redistribution order. So then the final way that you could be married is out of community of property and including the accrual. And what this means is that where there is a difference in your estate and your spouse's estate, you are entitled to a claim against your spouse if their estate has accrued more than yours. In other words, it's grown more than yours. You're entitled to 50% of the difference in the accrual. So I'll give you an example. If both of your starting values were 0 and your estate has not grown at all, so in other words, you are still worth 0, and your spouse's estate has grown by R1,000,000, you are entitled to a claim of half of the difference. So the difference in your accrual, yours is 0, your spouse is R1,000,000, half of the difference is R500,000, and you would be entitled to that. So the very important thing to know if you are going to embark on divorce proceedings is what is the value of your estate and what is the value of your spouse's estate. This is if you're married with an antenuptial contract, because that's the starting point. You have to know what was the value of your estate at the time you got married. That will be set out in your antenuptial contract. It could very well be 0. And what is the value of your estate now? And to find out exactly what the value of your estate is, you need to know what are your assets and the value of those assets, and what are your liabilities and the value of those liabilities. Because the one subtracted from the other generates the value of your estate. So to prepare yourself for a divorce then, or for divorce proceedings, you need to obtain documentary evidence of the value of both of your estates, yours and your spouse. Now, you may not have that information to hand when in relation to your spouse, so you need to find that information, or during the divorce process, obviously that information has to be disclosed. Now, in some of our courts, particularly in the Gauteng division, there is a document called a financial disclosure form, or an FDF, which the parties are obliged to produce and file with the summons or the plea in every divorce proceeding. And this document is done under oath. Now, it hasn't come into effect in the other divisions yet. So in the Western Cape, in KwaZulu-Natal, it's not yet a directive. It is coming though. And that document, so it's under oath, and it's very extensive. I think it's approximately 26 pages. And you have to set out everything relating to your financial position, including your income and expenditure and all those sorts of things. Because those things apply to and are relevant to, first of all, a patrimonial claim, in other words, the division of a joint estate or the calculation of the accrual, and also to a maintenance claim. And maintenance is what I will deal with in the next video. So I hope you found this helpful, and it gives you an indication of what you need to have in order to prepare yourself for a divorce. And it would be a good idea to go online and search for a financial disclosure form, because that will give you an indication of exactly the type of information that you are going to need in order to prepare yourself for the divorce proceedings.